if you could tell us how this could look different than the first trial, they could change the charges. They could drop that highest charge.
Could they?
They could. Of course, right now the district attorney is totally in charge in terms of the charges. They can also seek to plea bargain, which is something that I'm guessing they will at least talk about. If I were defense counsel, you owe it to your client to talk, and the prosecution could talk about whether they could reduce charges and reach some plea agreement.
Does the DA have to reach to the family and say, we're going to retry this case? What do you say? Or do they make that decision independently?
They won't make it independently. The family will and should have some say in that.
Yeah.
And they will talk with the family. I'm sure they probably already have. And my guess is the family probably wants them to retry it. In the end, it is the Commonwealth's case. So
right, that's why I asked.
It is the Commonwealth's decision. But certainly in this case, as in most cases, the complaining witnesses, the victims, have a lot to say about whether it's retried or not.
And in this retrial, will lessons learned be taken into account? I mean, both sides, you can imagine, will look to what they did in this first trial and potentially change the tact.
You'd hope that's true.
Right.
And if it's the same lawyer, you think you would have lessons learned both ways. Now, the defense also knows exactly where the prosecution is going, but the prosecution will look at this case and figure out, if we are to retry it, how do we make it more coherent? How do we, cut it down a little bit? How do we make it more, how could we get a guilty verdict?
Why did it get so, it seemed that it just kept extending and extending. And I remember David Bieniek was reporting live, and this was at the beginning of it, and he said, and this is going to go all summer long. And we thought, what? I mean, we have all covered major trials here, and I'm thinking Louise Woodward. I'm going way back, right? And you see this happening. But this seemed to be on another level. Maybe I'm wrong.
No, you're right. And I think because the prosecution and defense kind of knew the beginning and the end, but the jurors did not. They may not have gotten the clearest roadmap at the beginning of the trial where it was going. And in the way the trial started out, for instance, it started with a lot of witnesses, but nobody really saw it. You had lots of eyewitnesses to pieces of things, but not to whether he was hit by her car or not. And you had witnesses that you knew were going to be extensively cross-examined by the defense. So the first part of the trial was a lot of back and forth. Who do we believe? Whose memory is correct? Most witnesses don't have great memories. They may say it's something one time, they're not lying, but they misremember. But it gets confusing for the jury listening to who saw what when. Do we believe them? Was the defense effective? And look, you had two very experienced defense lawyers opposite the prosecution.
Well, and being on the periphery, we can read the reports that condense it, we can refresh our minds,
Correct.
But ultimately it's up to the attorneys to do that for the jury. And when you're in that room deliberating, you don't necessarily have everything at your disposal.
No, and although they take notes, people take notes in different ways. They may or may not be helpful. So I think this jury had a hard job to do.